Hello Askars, I am Indumani Karthikeyan from InKar IAS Academy. Today we are going to see about the 18th December current affairs. The topic taken from the daily edition, the topic is that legal gaps in India's unregulated AI surveillance. The topic which is taken from the daily edition, the topic which is comes under our GST policies and intervention for development in various sectors, and also there is a science and technology development topic. First of all, we must know why it is in the news. First of all, there is a emerging technology, then AI technology, that is artificial intelligence. In 2009, the Indian government made the headlines for announcing the intention to create the world's largest facial recognition system for policing. Over the next 5 years, the ambitious has materialized an artificial intelligence powered surveillance system that being deployed across the railway stations, and also Delhi police preparing the AI for crime patrols, and also there is a latest plan including launching the 50 AI powered satellite further intensify the India's surveillance infrastructures. There is a commendable thing that there is a technological integration in law enforceable. It's a very much commendable because it is make everything makes sense, and also there's a raises in substantial legal and constitutional concerns. It will create some constitutional concern, some dragnet surveillance, that is the AI surveillance as global parallels often resulting the dragnet, and also there is a term the indiscriminate data collecting beyond the suspects of the criminals, and also there is a section 702 that FISA that observe that section 702 of the Foreign Intelligence Surveillance Act in the United States as well intended surveillance law can result the overreach infringing the citizen rights. Actually they cover all the criminal records and everything, they can keep it, and also this will be sometimes overreach the criminal record with the citizens rights. And also there's a explore of the legal framework. This article explore the legal frameworks gaps and also concerns surrounding the AI surveillance of the India. There's an intersection with the constitutional right will examine the particularly the right to privacy will be completely can be mismatch with these provisions. And also there's a Telangana police data breach. First of all, we must know there's a revealed deep-rooted concern. The Telangana police data breach earlier this revealed the deep-rooted concern about the data collection practices of the Indian Law Enforcement Agency. And also that's according to the report of Hyderabad police that access databases of the social welfare schemes, including the Samgara Vedika, that is raising question about the scope of data being collected and lack of transparency in the usage of these things. And also there's a lack of proportional safeguard. That's a solution for the public welfare and the crime prevention is important. First of all, the data-driven governance offers solution of the public welfare and crime prevention. These practices must be measured against the individual right to privacy as guaranteed under the Article 21 of Indian Constitution. C.A.S. Puttaswamy as versus Union of India, the Supreme Court of India in C.A.S. Puttaswamy, that is recognize the privacy as a fundamental right, extending the scope of the information. This brings a challenge must addressed through the robust legal frameworks. And also there is a surveillance infrastructure, that is a currently that we are not having that much proportional safeguards. So this will legitimate concern about the implication of the AI driven data collection. And also there is a digital personal data protection is a important act. The purpose of this act is mainly which is passed in the 2023, that is provide a framework of the managing consent and ensuring the accountability of the data privacy in India. And also there's a many more criticism on board of exemption, that is a law has been heavily criticized because of the grant the government unchecked power to the possess personal data. First of all, there is some exemption in their concern, that is a section 7G, that is a DPDPA, that is a DPDPA waives the need of the concern when processing the data for the medical treatment during an epidemic. And also there's a 7I section. A further example, the government from consent required for processing data related employment, and also there's a particular concerning clause given the government India's larger employer, and also there's a potential for misuse can be happening. And that AI powered surveillance technology that operate on the worst qualities and quantities of the personal data, and also there's a section 15C of the DPDPDA introduces obligation for the citizen that could further exacerbate privacy concerns. So the section 15C mandate the citizen not suppress any material information when submitting the personal data. So punitive measures can be taken. The data accuracy could lead to the punitive measure for something as simple as the outdated address and also the technical error of the data collection system. These are the things, and also there's an unbalanced legal framework are there. That is item the scrutiny on individual data. That short DPDPA places which scrutiny on individual data while offering the government broad leeway in its use and collection, and also there is a skewed in favor of the state surveillance that is a given in a profound application of the AI technology in processing sensitive personal information, and legal framework appears that unbalanced skewed in favor of the state surveillance over the individual rights, and also there is a approach in the West that is EU regulation on AI. That is India is not around grappling the AI. The impact of the civil liberties that the European Union was enacted regulation that could serve as a useful guide for India, and also there's a right based approach that is a UU artificial act takes a risk based approach to AI activities, categorizing them into unacceptable, high transparency, and also minimum risk. There is a real time biometric identification, unacceptable risk activities such as real time remote biometric identification for law enforcement, and also there is a prohibited under the EU laws, and also there is a India's deployment of AI in policing. Lack of some legislative debate, that is a in start. There's a contrast. India has begun deploying the AI powered facial recognition technology and CCTV surveillance in the public spaces with little, it's no legislative debate on the risk management, and also there is a example of the Delhi and also Hyderabad that is a integrated AI into policing without any publicly available guidelines on the data is collected, processed, and also stored. That how potential abuses of the technology will be prevented. So there is a regulatory void in India. That is, first of all, the AM remains unregulated. So it is not regulated in the India, and also there is a promise of the Digital India Act 2022. So this is a act that under the upcoming Digital India Act, but draft legislation has yet materialized, and also there is a risk in the unregulated AI, that is AI power surveillance, including infringement, privacy, and also discrimination, and also there's a data breaches also can be happen during this kind of AI targetable use, and also there is a comparative legislation on the AI, that is a global trend, that is the countries such US and also the member of the European Union already have begun the legislation that use of AI in public, and also will clearly categorization and also give the restriction for the technology that could pose a significant threat of the civil liberties, and also there is an absence of the legal framework in India. The similar legal framework of India is troubling, especially given in the government ambitious plan to expand the surveillance capabilities, and also there is a constitutional concerns on AI surveillance. First of all, it will definitely violate the fundamental constitution questions at the core. There is a debate of the AI surveillance in India touches the fundamental constitution questions. First of all, it will affect the right to privacy, Article 21, and the principle of proportionally. The outlined the Puttaswamy judgment demand that any intrusion into the personal data and backed by law pursue legitimate aims and can be proportionate to the goal pursued, and stretching for the constitutional principles, that is a existing surveillance framework bolstered all AI technologies that appears to stretch these principles and their limits. There is a many things we need to address the impact of the liberties. First of all, we need to issue the unchecked applications. There is the AI governance is self problematic, but rather unchecked application without sufficient safeguard, and also there is a need for the comprehensive regulatory framework. That framework can be weakened we can completely, we need to do the framework for the AI data, and also there is a public disclosure is important to we need to in consonance with the right to privacy research framework including provision of the transparent data collection practices, and also there's a narrow and specific exemptions. That is a furthermore the framework ensure the consent gathering mechanism have narrow and also specific exemption for processing the data independent, and also there is a transparency and consent gathering is very much important to give the transparency in to the people, and also we need to ensure the consent gathering, and also we need to get the consent from the peoples, and also there's a adoption of the EU approach. That is a approach can be done by the EU, which is categorize AI activity based on the risk and pose of the citizens' rights. So first of all, we must know how to balance the constitutional rights with the AI. That is a critical juncture in AI surveillance in India. It is a crucial juncture in deploying AI-powered surveillance, and also we need to balance the technology with the constitutional rights, and also law enforcement and governance offers immense potential. It must be balanced against the citizen constitutional rights. First of all, privacy measures in infrastructure policy decision. To embed the privacy measure, there is a before deployment with internal inherent safeguard and surveillance protocol are vital, and also there's the importance of the pro deployment safeguard consent mechanism, transparency reports, and also judicial oversight. These are the important things. Finally, we need to conclude that the DPDP Act addresses some issues criticism persists. The long-awaited DPDP rules remain unnotified. The mitigate risk for the AI-driven surveillance regulating high-risk activities through the restriction on the digital personal data processing and transparent auditor oversight of data sharing is very much crucial, and also there's a proactive regulatory approach will ensure AI serves the public interest without compromising civil liberties. Thank you so much.